Welcome to TFE Talks, Navigating Wealth, Business, and Legacy, the podcast from Thomas Fisher and Edwards. Each episode, our attorneys bring you expert insight on estate planning, business strategy, and legacy building, breaking down complex topics into clear, actionable advice. Whether you're solidifying a strategy we've discussed or preparing for what's next, this podcast is your resource for thoughtful, practical planning. You ready? Let's dive in.
Welcome to another edition of TF&E Talks. Today, I'm actually, Dave Thompson, taking over the host chair for who is typically our host, Jordan Goway, at our firm, so that he can kind of educate us on a topic himself for once. So just for those that don't know, Jordan is a shareholder at Thomas Fisher and Edwards, and he is also a certified specialist in estate planning and probate law. And today he's going to cover the topics of powers of attorney. So glad to go,
excited to be on the hot seat today, David, instead of getting to be the one that asks all the hard questions.
Absolutely. So just to kick us off then, why don't we dive in, and what are powers of attorney, and when do they govern?
So a power of attorney, David, is something that we use in estate planning during a person's life. Mm-hmm. People come into our office and they think about estate planning as dealing with their will and things that happen after their death, but really estate planning can begin during life. Mm-hmm. And a power of attorney is simply a document where a client or an individual they give someone else the ability to act on their behalf with respect to certain decisions. And so that individual that is granting the power is known as the principal, and then they give one or more agents the ability to make decisions on their behalf during their lifetime so that effectively their life can continue on if they're incapacitated in some way or otherwise cannot act.
Okay. Well, I want to cover a couple terms that get thrown out when you're talking about powers of attorney, and then we'll pivot to the types of them. So a couple of terms that I hear a lot when people talk about powers of attorney are durable and springing. Can you just give us an explanation of what those mean in the context of powers of attorney?
Yeah, absolutely. So a durable power of attorney is most any power of attorney that you and I are going to prepare as part of an estate planning matter. And durable simply means that the power of attorney continues to be effective even once the principal is incapacitated. And so that's very important because that's what we are doing as part of our practice is incapacity planning. We want to make sure that someone's estate can continue to be managed if they are still living, but also have some incapacity and can't make decisions for themselves. And so that means that most any power of attorney that we are preparing is going to be durable. It's going to continue to be effective in the event of an incapacity. And in fact, will be expected to be used almost exclusively in the event of incapacity in most cases. And then you also mentioned the term springing. Springing deals with when the power of attorney becomes effective. And so a springing power of attorney would be one that only becomes effective when someone becomes incapacitated and then remains effective throughout their incapacity. And so that one, I would say, is a little more rare for us to prepare in the financial context, just because it requires the determination of incapacity. And when I meet with my clients, I typically advise them that if you're going to name this individual that you trust to act on your behalf in the event of an incapacity, then you probably want to name someone that you trust, even if you do have capacity and you have an ability to revoke the power at any time. And it's not worth the hassle of them then having to prove your incapacity in order to act, because there's that trust level there. And so I typically do not prepare springing powers of attorney in the financial context, though I will say that South Carolina's state healthcare power of attorney, just by its very nature, is a sort of springing power of attorney, because it only becomes effective if the principal is unable to make healthcare decisions on their own behalf. So springing just deals with when it becomes effective. Is it effective immediately upon signing, or does it spring into action upon capacity? And then durable just means that it continues to be effective throughout that incapacity period.
Yeah, no, I think that's a great explanation. And I would concur, in my practice, I would estimate that probably 90 to 95% of the financial powers of attorney that I prepare are effective immediately and are not springing. However, there are certain instances where it can be appropriate to have a springing financial power of attorney, and that can be something that can be considered.
Sure.
What, simply or briefly, can you give us the context of, financial powers of attorney are typically broad, Can you make a more limited one or specific power of attorney?
Yeah, so I would say that usually what we are preparing on the financial side would be what we call a broad or general power of attorney, which means we want someone to be able to step into the principal's shoes and do anything with their assets that the principal could do. Buy and sell assets, vote shares of a corporation or an LLC that they own, and so on. We want them to have broad capabilities because we want to be able to continue the principal's financial life in the event that they're incapacitated. But you could have a more limited power of attorney, and that would just be something where I give you the ability to do one limited thing on my behalf, such as with respect to voting stock. If you and I owned a corporation together, which we sort of do here as shareholders of the firm, then theoretically I could give you a limited power of attorney just to vote my shares if I was out of town or if I was incapacitated in some other way, and I just wanted you to have the limited ability to vote my shares, but I don't want you to be able to access my bank account. So sometimes what you may see is a general power of attorney with respect to most matters, but then a limited power of attorney with respect to voting shares or some specific aspect of a person's financial life.
Another one that you'll see a lot of is a real estate transaction. You'll
Right.
see lots of specific limited powers of attorney for just to effectuate a real estate transaction or something to that effect. So
Yep, absolutely.
That's a great point. So what are some of the, and we're going to start with financial powers of attorney, and then we'll turn into healthcare powers of attorney, but what are some of the specific considerations or decision points that you typically talk with clients about a financial power of attorney?
Yeah, so, just broad base, we're typically going to have that financial power of attorney be general. It's going to apply to really all aspects of the financial life. And so then the decisions that we're making beyond that are one, is it springing or is it effective immediately? And as we've already discussed, that's typically going to be effective immediately unless there's some particular reason that we need it to be springing. The other decision that we make, and probably the most important decision, is who is that agent going to be? We want to make sure that we pick the right person to be the agent so that they can effectively carry out their duties, but also so that they're trustworthy and that they don't abuse their discretion in some way that is detrimental to the principal and the principal's family. We also would like to have a couple of backup agents, and maybe we name two agents together as co-agents, and if we were to do that, we need to decide how do they work together. Do they have to agree on all decisions that they make, or do they get to act independently of one another? And there are pros and cons to both of those. If we require them to agree on decisions together, then that can be beneficial because we know that there's kind of a check on each agent and they have to really agree in order to sell a major asset that I own or something like that. But at the same time, it can be much more flexible to have two agents act independently of one another so that one of them can go to the bank without the other being there. And so there are trade-offs there. And then another big decision that we have to make is whether or not we want the agents to be compensated. I think in our powers of attorney, we practically always will give the ability for an agent to be reimbursed for actual costs that they incur while acting as agent. But I think oftentimes it makes sense for you to allow that agent to also be compensated for his or her time that they are spending as your agent. Because you take someone like us, we're attorneys, we bill hours for a living. If we were serving as agent under power of attorney on behalf of a family member and we were not able to be at work billing hours, that's going to hurt us financially. And there are, many other professions where it's going to hurt you if you have to take off of work to care for a family member and handle their finances. And so I think it's important to think through, do we need to compensate them for that time that they are spending acting as agent?
Yeah. No, that is the compensation question is one that I run into with clients frequently, and some of them may or may not be hesitant to provide for compensation, but I think generally speaking, if we trust the agent, especially in the case of a long-standing incapacity where the agent may have to act for that principal for a period of time that isn't just a few days.
Right.
I think it can be very important that we do provide for compensation in those cases, so that the agent can be properly compensated within reasonably compensated for the services that they provide.
Sure.
Transitioning to healthcare power of attorney now, how, I think you've already touched on some of this, but how does a healthcare power of attorney differ from a financial power of attorney?
Yeah, so the key with a healthcare power of attorney is that it is only going to apply during an incapacity. Okay. I always tell my clients that you are always able to make healthcare decisions on your own behalf until you get to the point where you cannot make those decisions. And then that is where it's important that we have a healthcare power of attorney. Because if we don't have one, then we probably have to go to court and get a guardian appointed on your behalf to make healthcare decisions at that point. And so we want to avoid those court proceedings. And so the healthcare power of attorney is an opportunity to name someone directly in the document that you have signed in advance, and also make several crucial decisions over how your care will be handled during a period of incapacity. And the other thing I'll note, just from a South Carolina perspective, is that another thing that's unique about the healthcare power of attorney is that it's on a state form. Anyone can just print off the state form and fill it out, and they have a healthcare power of attorney. I do recommend talking with an attorney about your healthcare power of attorney, just because there are decisions to be made in it. And I think we're pretty good about talking about those decisions with clients because we do a lot of it. But in general, there's no magic to the document. It's just a state form. It's not anything custom that we are preparing as attorneys in South Carolina.
Right. Yeah. And I think, the policy behind that is we want people to have healthcare powers of attorney. We want it to be easy to access. So I think, the form generally is readable for a layperson. However, as Jordan mentioned, there are decision points. And getting to that, what are some of the decision points that are in the South Carolina healthcare power of attorney?
Yeah, so the South Carolina healthcare power of attorney is going to give that agent broad range to make general healthcare decisions on behalf of the principal, what type of treatment options and things of that nature. But there are also 3 key decisions that are specifically in the form and that a principal will actually initial his or her choices with respect to. And so one deals with organ donation. It's not necessarily will or will not your organs be donated, but it's, do you give your agent who you've named in the document the ability to donate your organs? Do you consent to them being able to donate your organs? And so that's a straightforward yes or no question. The other 2 items that you declare in advance in that document deal with end-of-life decisions. And so one of those is life-sustaining treatment. If you have an illness that is incurable and irreversible, and a doctor determines that you're going to pass away in a relatively short period of time, if you're not artificially kept alive using life support, or if you're in a state of permanent unconsciousness, those are sort of the scenarios that apply. But in that situation, there are 3 options. And so the first option is maximum treatment. That means hook the principal up to a machine, hook them up to life support, keep them alive for as long as the medical ethics laws will allow. It's rare that I see my clients pick that option. The opposite option is also on there, which is no, I don't want life support if there's nothing that can ultimately be done for me in that situation. I just want to withhold or withdraw treatment with respect to life support. And then the third option is sort of an in-between option. It grants discretion to the agent who you've named in the document and allows that agent to make the decisions on the principal's behalf based on the facts and circumstances as they see at the time. And I would say that my clients typically have about a 50-50 split between that grant of discretion and the withhold or withdraw treatment. My older clients tend to go a little closer towards the withhold or withdraw treatment. My younger clients will typically grant discretion a little more often, but typically it's about a 50-50 split.
No, I think that's consistent with what I see as well, is that those are the primary choices that are selected. I don't have a lot of clients that will pick, maximum treatment. However, I've had it in the past, and ultimately it's up to the person preparing that, or the principal of the healthcare power of attorney.
Yep. And I'll note briefly, there is one other option in the, or one other item that has to be discussed in the healthcare power of attorney, and that is nutrition and hydration, which is essentially a feeding tube. But it's the same sort of layout with the options as the life-sustaining treatment. And typically my clients will pick the same option on that, whether they're granting discretion or whether they're withholding or withdrawing treatment. But it's similar circumstances and a similar decision with respect to a feeding tube.
Right. You want, typically, you'll want the same individual to be, make the decision for both of those aspects of the principal's care. Okay. So then one other thing I get a question from clients from time to time is about a living will. In South Carolina, I understand that's called a declaration of a desire for a natural death. But tell me what you know about living wills.
Yeah, so living wills, we get that question a lot because people always get that question at the hospital. They go into a hospital for a procedure and they get asked, hey, do you have a living will? And so what I always tell my clients is that we typically do not prepare living wills at our office unless you have one previously. And that's just because a living will does some of the things that a healthcare power of attorney does, but a healthcare power of attorney is a better overall document in my mind. That just comes in part due to history. Living wills were created by statute in South Carolina in the 1980s, and then healthcare powers of attorney were created by statute in the 1990s. Living wills only deal with those end-of-life decisions that we were just talking about, when you have an illness that's incurable and irreversible and you're going to pass in a short period of time. It doesn't deal with all the general healthcare decisions that a healthcare power of attorney deals with. And so really a healthcare power of attorney can cover all of that and more. But we run into issues when people have both documents because they often will mistakenly, especially if they fill these out on their own and don't talk to an attorney, they'll make inconsistent decisions on the two documents. They'll say withhold or withdraw treatment on the living will, but then they'll grant discretion on the healthcare power of attorney. And that can be problematic because the living will in that scenario overrides the power of attorney. And so for my clients who are just off the street, they've never done estate planning before, we just prepare a healthcare power of attorney because I think it's a better overall document. If my clients come in and they already have a living will, then we will either restate that living will to ensure that that they make the same decisions at the same time as they do with the healthcare power of attorney, or we will just withdraw that living will or revoke it so that they can rely only on the healthcare power of attorney going forward.
Yeah, exactly. And, I tell clients that, the healthcare power of attorney, in addition to addressing the concerns of the living will, also provides, the individual that can make healthcare decisions, big and small, in other periods of incapacity. For example, if you go in for knee surgery and you're incapacitated for a period of time and a decision has to be made, well, that's not necessarily maybe life-threatening, but the agent can make that decision. The living will doesn't really address those features in its current form.
Exactly. And so for those who do have a healthcare power of attorney and you go to the hospital and they ask you, hey, do you have a living will? Because doctors don't necessarily know all of the law behind it. The answer to that should be, no, I don't, but I have a healthcare power of attorney. Can I put it on file with you? Because ultimately that ends up being important.
Yeah, I completely agree. I think that was a really helpful recap of powers of attorney. And I think one last thing I'll leave the listeners with is that, powers of attorney are something that, everyone should have, right? Yep. I think we get a lot of questions about, should I have a will? Should I have a trust? And those are, I think, specific to each circumstances. And I can realistically think of some situations where maybe you don't need a will, potentially. If you're young and don't have a lot of assets, I think you should have one, but it's not maybe necessary truly. But almost every individual, in my opinion, should have financial powers of attorney, healthcare powers of attorney. And I think this gives us a nice summary overview for people that are listening.
And just to tag along to that, I would say think about that for your loved ones as well. So like, husband and wife, you're 50 years old, you have all of your estate planning documents taken care of, but then your child is 18 years old and they go off to college, they should probably have a healthcare power of attorney and a durable power of attorney so that if they got in an accident or something while off at college, you can step in, assuming that you are who they would name as the agent, that it's the parent, you can step in and make those decisions without having to go and get appointed as their guardian because you probably don't have the same control over their lives that you had before they turned 18.
Yeah, and I think on the inverse side of that too is for older family members, making sure that these are in place is really important as well, because one thing that we didn't touch on is that, especially in the context of a financial power of attorney, that older individual may need a heightened level of capacity as compared to preparing testamentary documents, which have a different level of capacity that's required. So I think ensuring that your loved ones that are upstream of you, your parents, maybe other relations that you maybe would assist in this, have these documents in place can really be a time saver for a lot of clients. Yep. But I appreciate everyone for listening, and that's the end of this edition of TFE and TF&E Talks.
Thanks for listening to TFE Talks. For more information, please visit our website at www.tfelawfirm.com. You can also follow us on LinkedIn, Facebook, and Instagram by clicking the links below in the show notes. If you have any questions about topics discussed in the episode, or you have recommendations for future topics, please email us at info@tfelawfirm.com. See you next time.